Greetings, greetings, greetings. This is part two of my lecture for Module 2, the week of July 6th in this summer intensive course on human rights law and government. And being in week 2, this represents 25% of the course. So we're moving quickly. Please, I strongly advise, encourage, and ask that you keep up. I noticed even now that we're about 1 week into the course, some of you have not even gone on to Canvas. So that is not a great sign. It kind of shows me I can see not what you're doing on Canvas, but whether you've even gone on Canvas or not, and the amount of time spent on Canvas. So please, I hope you can make sure to stay. Don't make sure not to fall behind. If you have any questions or concern, always reach out to me at t.walsh@hji.edu, and I'll be happy to do everything I can to help or assist you. But let me go through this second presentation that I hope simply further supplements what was in the previous presentation and PowerPoint. Here we go. All right. So constitutional law and constitutional rights. Just a quote, before the 17th century, the word rights had a surprisingly limited meaning in English usage. In a legal sense, a right was nothing more than a valid title of ownership as it related to real property. But amid the great political and religious disputes of the 17th century, the word right shed its original limited meaning, began to acquire its bewildering modern association. So the rights has become a very prominent word, part of the legal landscape of the world. Human rights are underscored. There's a Universal Declaration of Human Rights and various covenants on human rights, on civil, political, economic rights, social, cultural rights, etc. So we'll be digging into that more as we move along. What are rights? These are legal entitlements to have or to be in a position to obtain something or act in a certain way. If you have a right to freedom of speech, then you are able to speak freely. If you have a right to vote, then you have the right to act on that right and vote in an election. If you have right to some form of social services or a pension or social security check, then you are entitled to that. So rights come in two ways to think about rights. One is they are rooted in natural law. So if you read the Declaration of Independence, that it says, endowed by our Creator with certain unalienable rights, life, liberty, and the pursuit of happiness. That would be more of a natural law, that these rights, if we say they're given by God, or they're rooted in the nature of reality as created by God, and so that we don't invent them. We don't sit around thinking, what kind of rights should I come up with? These are the rights that the human mind is able to intuit or understand naturally by having a rational capacity. So the right to life, meaning that no one is entitled to take away my life. That is a violation, a fundamental violation, to attack my being, to harm me, particularly if I've done nothing to provoke that attack. But that is viewed by many as a natural right. You could say it's common sense. It's intuitively something that all people recognize. So that is a right rooted in natural law. There's also rights rooted in what's called positive law. Now, positive law is a generic term for laws that are created by a legislature. So if you pass a driver's test, you are then given a license, which gives you a right to drive a car. If you're over a certain age and you pass the requisite tests, then you thereafter have a right. That right can be taken away if you violate many of the laws related to safe driving. But that right doesn't come originally from God. It is a right that is given to the citizens of a particular state based on a legitimate body of government, a parliament or a Congress, to enact a law. And that's what's called positive law. So if we stay in the area of positive law rather than this natural law, which is a little bit more philosophical and seen as kind of universal and fundamental to human existence, knowable just by the fact that we are rational creatures. But if we stay positive law, which means you might say legislation that entitles me to certain freedoms or benefits of being a citizen. So these positive law rights come about through common law. That means common law is the tradition of laws that build up over decades and centuries in a country and are written down, and that becomes a kind of legal tradition that is referenced when court cases come up. You refer to the common law, the tradition of law that has built up over time through decisions by the courts. Then there are positive law rights that are written into the Constitution, as we've seen with the U.S. Constitution, or you will know from constitutions of your own country if you're not a U.S. citizen. So rights can be, for example, the amendments to the Constitution of the United States are outlining certain rights that citizens have. Initially, these are rights to protect you as a citizen from government interference in your life. Like the Second Amendment is about the right to bear arms, that citizens with the right qualifications can purchase a weapon for self-defense in their home or for hunting. That is a right that's written into the legislation, or in case of the United States, in the Second Amendment of the Constitution. These positive rights are created by a legislature or another branch of government. For example, the Supreme Court made a decision about abortion in Roe versus Wade in the early 1970s, 1973, passed the Roe versus Wade decision, gave women the right to an abortion. This was later overturned by the legal system, whether a woman has the right to terminate the life of a fetus growing in her womb or not. So that's an example of a right that can come from the court, or it can come from the legislature. And then there are rights that come with private contracts, that if you sell me a car and we sign a contract, I'm going to pay you $1,000 and I get your car, then I have a right to receive the car and you have the right to receive the $1,000. And if either of us violate it, we violated the rights according to our contract or agreement. And constitutional rights generally are restrictions on government conduct. It cannot violate my freedom of speech, my freedom of assembly, or the media's right to report as it sees fit. So there's a little bit of background on rights, which we'll go into in more detail. Looking a little bit more at John Locke, he talked prior to the Declaration of Independence in the 17th century about unalienable rights endowed by the Creator. He spoke of life, liberty, and property. So when we look at the Declaration of Independence, this didn't just come out of nowhere, out of imagination, but a stock of knowledge that kind of stood on the shoulders of other giants. And in terms of Locke, he had ideas about how governments are formed, how a legitimate government is formed. A legitimate government is formed because it has been empowered by the people rather than the government taking over and controlling the people. The people form the government. The government exists on the foundation of the consent of the people, the consent of the governed. That term, the consent of the governed, is the foundation for government. And this concept of a social contract. Due to the social contract, written into the contract is the formation of a government, and the Constitution articulates the various details of the formation of that government, that it'll have an executive, legislative, and judicial branch, for example. So the people agree or consent to giving powers to the government. It consents to giving policing power to the government. Now, it can be ultimately checked by the Congress and the people's voting a particular government out of office, but for the day-to-day enforcement or policing, to keep the society stable and to keep criminals and those who would prey upon other citizens, to keep them either imprisoned or constrained, then you need a police force. So it's a central aspect of government to keep the domestic peace and to protect the borders from external threats. But that the government, according to Locke, only possesses those powers that have been granted by the people. Locke believed that the law of nature limited what may be accumulated and decreed. So although Locke believed in life, liberty, and property, there was a limit on the acquisition of property, so that it shouldn't exceed a certain amount that would, and the excess would be to deprive a needy brother or sister of a right to the surplusage of his goods. So a certain moderation in terms of acquisition. So it talks about honest industry, honest work, but also a heart of charity to give to others. If one has excess, that one shares that with others. For God requires him to afford to the wants of his brother and sister. This is John Locke. And then Montesquieu, who we've spoken about, he came up with the concept of there are three primary forms of government that different countries can adopt. One is a republic, such as the United States, which is more democratic, rooted in a love of virtue, put the community ahead of private interests. Then there's a monarchy that he described as more based on rank, privilege, and hierarchy, with a central person at the top who had very, very strong executive authority, if not absolute authority. This was a society guided by a love of honor. And then there is a despotic, a tyrannical form of government where there's fear of the rule. Not all monarchies are despotic and tyrannical, but some are. Then Montesquieu spoke about the separation of powers. He was the first to clearly articulate these divisions of government into an executive, that there needs to be an executive who has capacity to make important, quick decisions often. And there's also the legislative, which takes more time to make decisions. It's a larger body, a lot of dialogue, debate, and division and argument to come up with decisions, but yet that's necessary, and representing the diverse voices of the people. And finally, a judicial branch that, with the Constitution in one hand, looks at whether laws themselves produced by the legislature or enactments of the executive violate the Constitution. So the judicial system is kind of looking from a higher perch on the exercise of government by the executive branch and legislative to take note if there are violations of the Constitution. Also, preservation of liberty requires due process of law. That means that every person who is accused of a crime is, we could say, presumed to be innocent until proven to be guilty, and goes through a systematic, unbiased exercise before a judge, even a jury, to evaluate the evidence of a case fairly and equitably to arrive at a fair decision of guilty or not guilty, and if guilty, what is the punishment? What is the appropriate punishment? Other constitutional systems around the time of the American Revolution, Simón Bolívar in South America was also stimulated to try to create a United States of Latin America or South America. This did not end successfully, and Bolivar ended his life more or less disgraced and a failure in his ambitions. And Latin America did not unify in the way that the United States did. There are various ways in which Latin American nations come together, such as the Mercosur nations in southern South America. These are nations like Argentina and Uruguay and Chile. I forget all the exact nations, but a kind of coalition of nations. There's the Organization of American States that seeks to bring this together, but there's no central government to Latin America or Central America or the Caribbean. In the Caribbean, there's CARICOM. It's more like an economic cooperation, but not, again, a central government. In the Republic of China, which is Taiwan, they have 5 branches of government. In addition to the 3 standard legislative, executive, judicial, they have a civil service branch and an auditing branch. Some say the U.S. has a 4th branch in the form of its bureaucracy. Some call that the deep state. And Reverend Moon has talked about the branches of government in a very spiritual way, linking it to the way in which God designed the human body. And this is a quote from the Exposition of the Divine Principle. So again, the core American documents, we can go back to 1620 in the Mayflower Compact, to 1776 in the Declaration, to 1787 in the U.S. Constitution, and 1789 in the Bill of Rights, a rendering of the signing of the Mayflower Compact on board the Mayflower, the ship that they sailed over. This is the length of it from 1620. Beginning in the name of God, amen. And it's a very short, but it is an example of a social contract, an agreement that they will stick together, form this union, and begin with a system of governance, even though this is not a large population of a couple of hundred of people, but they form the basis of that Plymouth colony that became, in many ways, a symbol of the New World and religious freedom in particular. And that Mayflower Compact in November of 1620 for the glory of God and the advancement of the Christian faith, they say. We do solemnly and mutually in the presence of God combine ourselves in a civil body politic, meaning a civil government, basically, for the general good of the colony. We promise all due submission and obedience. That submission is on the one hand to God, but also to this compact, that they surrender certain freedoms to this community so that we may be preserved and work together peaceably together. That is some core dimension of citizenship. It's voluntarily agreed to that I will be a citizen of this country, and with that citizen, I have duties to the state, and I must abide by this compact, this contract, this Constitution. Thomas Paine was essential as a writer who stimulated many in the developing the Declaration of Independence and the Revolutionary War. He writes before the Declaration of Independence, the time had come to correct the errors in Britain's constitution and to found new governments free of kings and hereditary rule, governments in which all officials owed their power to popular choice, not to the inherited power of a monarch. And here, the Declaration of Independence, which you've studied and are writing about, all men are born equally free and independent. All men are created equal. So this was language that George Mason had drafted, and Jefferson's Declaration wrote, all men are created equal. And Mason had written in the Virginia Declaration of Rights, men have certain inherent natural rights of which they cannot by any compact deprive or divest their posterity. Jefferson shortened that to all have unalienable rights that cannot be taken away. from a human being. Again, George Mason had written in the Virginia Declaration in January of 1770 that these rights, among which are enjoyment of life and liberty, with the means of acquiring, possessing property, and pursuing and obtaining happiness and safety. So the Declaration ended up saying, endowed by decree with unalienable rights of life, liberty, and the pursuit of happiness. This just shows something of the kind of editorial process leading up to the Declaration of Independence. Many decades later, at the time of the Civil War, Abraham Lincoln writes about the founders, saying that the founders meant simply to declare the right so that the enforcement of it might follow as fast as circumstances should permit. They meant to set up a standard maxim for free society, which should be familiar to all and revered by all, constantly looked to and constantly labored for, even though never perfectly attained, constantly approximated, and thereby constantly spreading and deepening its influence and augmenting the happiness and value of life to all people of all colors. He's talking about slavery, but all the ideals envisioned in both the Declaration, the Constitution, and we could say the Mayflower Compact and the Bill of Rights, that there is a certain sense in which these are aspirational ideals, given the fallenness of human beings, the sinfulness of human beings, that would only be fulfilled by the grace of God over time. And Lincoln had that longer term vision. Even Martin Luther King spoke about the arc of history bends toward justice. It doesn't happen like that. But we have to believe that humanity, and we have to work toward the vision of humanity continually improving its moral, spiritual condition, and greater equality and respect and love for one another grows consistently. This idealism is found in another great American named Theodore Parker, who had an idealistic view of democracy. And he says, democracy, I mean government over all the people, by all the people, for the sake of all. This is not a democracy of political parties, but it is that ideal government, the reign of righteousness, the kingdom of justice, which all noble hearts long for and labor to produce, the ideal whereupon mankind slowly draws near. And again, also writing in the present crisis. This is just prior to Lincoln and the Civil War, Lincoln's election. Parker writes, "Here is the American program of political principles. All men are endowed by their Creator with certain natural rights. In respect thereto, all men are equal. The Constitution itself is a provisional compromise between the ideal political principle of the Declaration and the actual selfishness of the people of North and South." So again, these are aspirational, just like the New Testament is aspirational. It calls us to become people who love God, respect God, and follow God's will and commandments, but continually fall short. Likewise, Parker saying that we are the mix, in a sense, between fallenness and redemption or salvation, or we're on a road of restoration that occurs over time. Again, from Parker, the American Revolution with American history since is an attempt to prove by experience this transcendental proposition, to organize the transcendental idea of politics. The idea demands for its organization a democracy, a government of all, for all, and by all. This is his idealistic view of the Constitution. The Articles of Confederation was the initial Articles of the 13 colonies, not yet come together as a single government, a federal government with 13 individual provinces or states. So this is an excerpt from those articles, which were created right after the Declaration. They needed some way to kind of coordinate the 13 colonies. This was not yet a constitution. That comes some 10 years later with a constitutional convention. But the Articles of this Confederation shall be inviolably observed by every state, these 13 colonies. And the union shall be perpetual, nor shall any alteration at any time hereafter be made in any of them, unless such alteration be agreed to in a Congress of the United States and be afterward confirmed by the legislatures of every state. So it was very difficult to amend these Articles of Confederation from 1777, which only endured through the Revolutionary War shortly thereafter. And 10 years after these articles were created, a constitution for a single unified government was drafted and ratified. So in 1787, James Madison and Alexander Hamilton called these 13 states together to ostensibly to amend the Articles of Confederation. But in fact, they ended up drafting a new federal constitution, not a confederation, but a single federation, federal government that governed over all 13 colonies. Now, states had also their ideas of crafting their government structures as independent states, but eventually the Federalists won out over the Confederalists. The Confederation would be more loosely allied, like treaty. It might be something like the European Union or Association of Southeast Asian Nations or the African Union, without a strong single executive. So the Constitution got drafted with the key features being the separation of powers, that President and Congress are elected, and it stipulates how judges are appointed, how government officials can be dismissed, fired, the relationship between the federal government and the states being subordinate to the federal government, and the rights of a citizen or inhabitant of the U.S. The issue of slavery was brought up and different measures taken again to moving toward some appropriate treatment of slaves that took the Civil War eventually in 1660 to 65, the greatest war ever carried out on American soil, to lead to the Lincoln signing the Emancipation Proclamation. So the underlying principles of the Constitution: separation of powers, federalism, that the central government is the supreme power and the states are subordinate. Also, the Constitution respects individual rights, and what we call rule of law, that all people live under the regulation of the law. No one is above the law. This is a core principle of good governance. This was a foundational concept for the United States of America. And again, rule of law is not always practiced globally. Many persons, individuals in positions of great power will bend or violate the law due to their great, even yet illegitimate power. Subsidiarity means that the states are subordinate to the federal government, but that the states can establish their own state-level laws as long as they do not violate the Constitution. So there's a certain decentralization of authority. A state has a governor. A state will have its own legislature and its own courts, but they cannot secede from the Union, and they cannot violate the core Constitution and federal laws and requirements. This is about the ratification of the Constitution, and also how new states may be admitted into the Union. So it starts out with 13 states, but now, as you know, we have 50 states in the United States. This is a little bit about the ratification process. 9 states did ratify, 9 of the 13 initially, eventually all of them, but 9 was necessary to pass the Constitution. And a new government was established 1789. Washington was sworn in at Federal Hall in Lower Manhattan here in New York City on April 30th, and the new Congress convened. So the government was brought into being. And then the 14 amendments to the Constitution were also presented along with this Bill of Rights. Amendments is essentially the process of how we can make changes to the Constitution. So if we look at the hierarchy of law in the U.S., the Constitution is the supreme law of the land. U.S. statutes enacted by Congress and treaties made by the executive, ratified by the Senate, are second in terms of their hierarchy of authority. Then U.S. regulations, laws by the executive that apply to everyone. And after these kind of federal level laws, you have state constitutions, state statutes or laws, and state regulations. So there's a hierarchy here that leads up to the supreme law being the U.S. Constitution, which is also protected by the Supreme Court, who makes sure that laws throughout the hierarchy do not violate the Constitution. So again, these are the 7 articles of the U.S. Constitution and the areas that they cover and study. The legislature or Congress, a bicameral system, the upper and lower house, deals with issues of commerce and regulation of commerce between states and with other countries. Article 2, the executive, the judicial in the 3rd article, the Bill of Rights that were the first 10 amendments to the Constitution as listed here, freedom of religion and speech in the first, right to bear arms in the second, how governments could they take over your home to allow troops to stay in your home. That was prohibited, and search and seizure. There must be regulations that restrict search and seizure, that you can't just come into my home and search it. You must have a warrant that has been granted. This is about due process of law. This concerns criminal prosecutions, that you have the right to a jury trial. You have a right to confront the charges and to declare you're not guilty, and to seek and to obtain counsel, meaning an attorney. The 7th Amendment talks about the right to a jury trial. The 8th Amendment prohibits excessive bails or fines or cruel and unusual punishment. The 9th Amendment says there are rights that may not be enumerated in the Bill of Rights that are still natural rights that every citizen must enjoy. And then the 10th Amendment talks about rights reserved to the states or the people. So later amendments, coming later, the 13th Amendment abolished slavery at the end of the latter part of the Civil War, defined the citizen. The 14th Amendment, 15th, granted voting rights. 18th was prohibition. That means outlawing the production and use of alcohol. And the 19th was giving women the right to vote. The 21st Amendment, the prohibition, was repealed. An amendment made in 1919, then some 24 years later, or 14 years later, it was repealed, meaning now alcohol is okay to produce and consume. So the 10th Amendment, Congress may not legislate directly on a matter that is exclusively within the police powers of the state. This goes back to this principle of subsidiarity, that the states do maintain certain powers that they can carry out and exercise independently of the federal government, but they must not be in violation of any federal law or constitutional principle. And this is a statement about the police power and how best to define it, given that the states also have this policing power within the jurisdiction of their state. Now, there are a lot of debates in America about amending the Constitution or the authority of the Constitution, and these are views of what in biblical studies would be called hermeneutics, or how we interpret the text. And there are listed here 3 types: textualism, originalism, and non-originalism, or living constitution. Textualism says simply read the text and the common sense reading or interpretation will emerge. Originalism also seeks to understand the original context in which the texts were written nearly 250 years ago to best interpret them. So going back to the origin. And then there's something called non-originalism or living constitution, which where we seek to understand the underlying principles and apply them to contemporary reality. So the Constitution kind of has a dynamic meaning. This is a more liberal view of the Constitution. The originalists are more strict foundationalists, and these are strongly debated even among members of the Supreme Court of the United States. So this draws to a close my lectures for Module 2. Please stay in touch. I think I'm going to set up a time for us to meet by Zoom. I'll schedule something for a short meeting. If for some reason there's a time zone or schedule conflict, just let me know. Just look for that. It will be in an announcement. Thank you for being part of this course. Email me anytime with your comments or concerns or questions. And please stay active in terms of the reading assignments and your weekly writing assignment. I know it's a lot of work, but again, we're condensing this course into 7.5 weeks. So it requires more attention than drawing it out over the 15-week period. Also, there's a term paper requirement, so you can begin thinking about the topic you'd like to write about for your term paper. Okay, wishing you all the very best. Stay in touch. Thank you.